So when in preparing for mediation, probably the best thing to do is have a familiarity as to your finances. And just by way of example, if there's a home, who owns the home? Where's the deed? Do you know where the deed is? What about the income tax returns? What about W-2s? Because often we are talking about ongoing financial support. We're also sometimes talking if there's children that need to be supported, we're talking about that. And we're also talking about buyouts of property. So to have a general idea, and it doesn't have to be perfect, but just have an idea as to what the assets are, some documentation relating to those assets, and bring that along with you. Or what we prefer to do in our program is give it to us in advance. That way the mediator is there, the mediator is prepared, and we're not wasting your time, or quite frankly our time, getting all that together, because the mediator has already done it and has an idea as to what's going on financially and can ask very poignant and direct questions that are going to be relevant to your matter. So before coming into mediation, you really should have some goals and some understanding as to what is your hill to die on, as some people say. What are the things that I'm absolutely not willing to give up? Whether that be the painting, whether that be weekends with your children, whether that be the home, those things. But those things should be realistic. And it is always a good idea to have an idea as to what the law provides for, because all of our mediators know the law, and they're going to tell you whether or not that is something, whether that is a hill to die on, or whether or not you have to be reasonable and make compromises. You have to go in with a mindset that I might not get everything I want, but I am going to take control over my life, and this is what I can live with. It's never I'm getting everything I want and I'm walking away totally happy. Just mathematically, we can't divide 1 into 2 and everybody is happy walking away. It's not going to happen. So what can I live with? What can I tolerate? And what is the best outcome for me? And what are the things that I absolutely will not give up? And those things should be revealed to the mediator. Let the mediator address those harder things in the beginning, and let's see where we go with that. When you're planning your day for mediation, what we're doing to make it a little bit more convenient for people is we will meet with people in person if they wish, but we're scheduling things by Zoom, by Teams, whatever internet channel people want to use. That actually makes it a little bit more comfortable for people. And I think also because oftentimes we're asking for documents, or we're asking for things, at least you're in your own space. And at least in your space, you can get us stuff that you need. And you're on your computer, of course. So most things are digital these days. The other thing that we do want, and we have done this where we have both parties together on Zoom together on the same screen. And we've also told people maybe you should separate in case the mediator wants to talk to you privately. So your day for mediation can be as long or as short as you need it to be. Personally, when I'm mediating, what I like to do is have people either set aside like 2 to 4 hours, a morning or an afternoon. I think all day is too much. I think 1 hour is a little bit too small. So really set aside some time for us and just understand it's going to be a few hours out of your day. But at the end of it, I don't want you to feel exhausted. At the end of it, I don't want you to feel like it was a waste of time. That's why I think just making it half days is really, really best for most people. Mediators are neutral parties. Mediators are not there to advise you on the law, so to speak, but all of our mediators are lawyers. All of our mediators are either retired judges, all of our mediators are experienced litigators. So they do have a subject matter absolute specialty in this area. They know what they're talking about when they tell you what the law is, but they're not there to advise you on the law and whether or not you should accept something or not accept something. Also, people, especially for some reason in the family law, more than any other law that there is, people have unreasonable expectations of what the family law is and what the family law will provide for you if you do decide to litigate and you are in front of a judge. So when you're doing mediation, I think people should be strong consumers. I think they should know what they're talking about. I always recommend that people have a very good solid legal consultation before they come into mediation, so that they do have some kind of expectation and they do understand some of the terms that the mediator might talk about. So just by way of example, the mediator might say, well, that's not pendente lite, or that's not equitable distribution. You really should understand what those terms are before we're talking about them. The difference between spousal support and alimony, are these two things the same? What's maintenance? Just understand what the lingo is a little bit before you come in, and be an informed consumer. In other words, the whole idea behind mediation is you're taking charge of your own life. How do we do that? We do that by knowledge. Having knowledge makes us powerful, and you want to be a powerful participant in your own life. So getting a good consult, I would say definitely do it. If you have any questions about preparation for mediation, please take a look at the rest of the videos in the video libraries, or feel free to call us. Schedule a consult, take a look at our website.